My name is Chris Fortier. I am the chair for the conference, and I'd like to thank you for joining us today. And now for our next session, I'm going to introduce our presenters. Since 1998, Mark Bassingthwaighte has been a risk manager with the Attorney Liability Protection Society, better known as ALPS here in Virginia, which is an attorney's professional liability insurance carrier. In his tenure with the company, he has conducted over 1,000 law firm risk management assessment visits, presented numerous continuing legal education seminars like this one throughout the United States, and written extensively on risk management and technology. He received his JD from Drake University and his undergraduate degree from Gettysburg College. Barbara Saunders is an assistant ethics counsel at the Virginia State Bar, which she has held this position since 2001. She staffs the Ethics Department hotline, providing ethics advice to members of the Virginia Bar, and is also a staff liaison to the Bar's Standing Committee on the Unauthorized Practice of Law. Prior to joining the Virginia State Bar, she served in private practice for 12 years and was a partner at the law firm of Poindexter and Schorsch in Waynesboro, where her practice focused on domestic relations, workers' compensation, and Social Security disability. Prior to practicing in Waynesboro, Ms. Saunders practiced in Richmond. She graduated from Mary Washington College with a BA in International Affairs, and she has her JD from the T.C. Williams School of Law at the University of Richmond. So, Mark, Barbara, please begin.
Thank you, Chris. Welcome. You will note, if you've taken a look at the materials, that there are, I think, 22 hypotheticals out there that we're going to chat about. In the hour that we have, there's no way that we can get through all 22. So Barb and I have picked ones that we think are especially interesting and relevant. Both of us are fairly informal presenters in terms of feeling quite comfortable. If you have questions to ask, we certainly invite you to ask a question. Don't hesitate to raise a hand or something like that. Washington and Virginia Beach, if you want to just approach a mic, and I'll try to remember to check in periodically with you folks, but happy to entertain questions from you folks as well. We're going to just start with a few at the beginning, and I'm going to read through the hypos. We'll see what you folks think, and then we'll share our thoughts. We're going to start again with number one, and the hypo is, you and your law school roommate have continued to stay in touch with each other and debate some of the issues that you covered together in law school. Over one recent lunch, your friend took the position that lawyers could be professionally sanctioned for discourteous behavior. You have always tried to act as courteously as possible, but you wonder whether lawyers falling short of such behavior could suffer bar discipline. So the question is, do the ethics rules prohibit discourteous behavior? Thoughts? Does anybody? What do you think? Show of hands, yes. The rules prohibit discourteous behavior. We got a number of hands up. That's interesting. Barbara, what are your thoughts? You're sitting in the chair that, in terms of your role.
Well, the answer is, as far as is it an ethical violation to exhibit discourteous behavior? And the answer generally is no, unless it is really something really extreme, and it goes to what would possibly come under our Rule 4.4, which is either 4.4 and perhaps 3.4 J, which is essentially taking action on behalf of a client in any manner that the only purpose is to harass or maliciously injure or take advantage of another, to overburden another. In those extreme cases, you could have an ethical violation. For just the instances that we hear about frequently, where lawyers act just really unprofessionally, uncivil, stupid, that we can't regulate. And I don't want to say whether that's fortunately or unfortunately. Sometimes it's unfortunately, because in some circumstances you really wish you could slap somebody's hand, but it is sometimes frustrating. Lawyers will call us on the ethics line, which is another service that the ethics department provides, which I hope you all are aware of. But lawyers will call us and say, Lawyer X just said this horrible thing in a deposition, or did this in court and made this allegation, or made this statement, or acted like this, or didn't do this, or didn't do that. And while we are truly sympathetic to the fact that that is uncivil and unprofessional behavior, it is not always going to be unethical. So that's something to keep in mind. That said, as part of this whole program, one of the centerpiece documents in the appendix are, if you haven't ever looked at them closely, are the rules or guides to professionalism that the Virginia Supreme Court endorsed several years ago. They're not anything that you can be disciplined for or sued on, but the court, and really most everyone in the profession, would say that the court certainly encourages that this behavior that is suggested by these rules and guidelines are what we should all exhibit, and by which we should conduct ourselves. So that's the long answer to a relatively short answer.
Let me just share a thought as sort of a guy in the risk management malpractice arena. You know, you do see lawyers out there that say, you know, unless it explicitly says I can't do this, you know, I'm going to try and go for it and get away. And it's always under this banner of zealous representation, these kinds of things. And my response is, come on. You know, I don't see the ethical rules as, you know, this low thing that kind of just some guidelines. To me, and let me come at it this way. It's not a ceiling. It is a floor. And it is something that we stand upon and rise above. And these professionalism principles are, you know, there's a reason that they've been developed. You know, we have the great privilege to practice in a profession that, if you will, polices its own. We're a self-regulating profession. But we are also, and you know this, are under attack from a variety of sectors. How long do you think we will continue to maintain the privilege of self-regulation if we don't seek to truly live and you know, be the professionals that we, at least on paper, say that we want to be? So I just leave that as a little food for thought. Question or comment before we move on? Let's take a look at hypothetical number 2. You just hired 2 new lawyers and 1 new assistant. The lawyers recently graduated from law school, and the assistant had previously worked only for doctors. Now, having been a sole practitioner until now, you wonder about the ethical and professional implications of bringing on new folks like this. This is kind of a two-parter. Do you have any responsibility for assuring that lawyers and non-lawyers that you supervise comply with the ethics rules? By the same token, you go, can you be held responsible for any ethics violations by lawyers and non-lawyers you supervise? Well, let's look at A first. Again, just a little show of hands. Let's see where. Do you have a responsibility for assuring that those in your employ abide by the rules? Yes? Okay. Can you be held responsible for an ethical misstep by someone that you are supervising, lawyer or staff? Yes? Do we have any no's on either of these? Okay. Well, Barbara, I'll let you start, you know, and let's share some thoughts on this one. I've got some things to say about it.
Okay. The answers are to both of these questions are yes, with some qualifications. We have two rules that apply. One is Rule 5.1, the other is Rule 5.3. 5.1 addresses the duties to supervise other lawyers. 5.3 addresses the duties to supervise non-lawyer staff, and that includes not only non-lawyer staff that work with you within your practice, your firm, but also any non-lawyer that you hire that works with you. So that could be investigators, that could be outside consultants that you use, are all encompassed within Rule 5.3. Basically, taking the lawyer supervision, if you are a partner, and the actual language of the rule is a partner in a law firm or a lawyer who individually or together with other lawyers possesses managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. Now that's a very general, very broad statement. The rule does not then, and we've been asked about this many times, the rule does not then go into minute detail of how you do that. It's just that if you are a partner or in a supervisory position to other lawyers, it is your responsibility to make sure that those lawyers under your supervision are aware of the rules of professional conduct. They should have them available to them, know where they are, to find them, to refer to them, to reference them, and that they understand generally how the rules require lawyers to conduct themselves. Now, how the actual mechanics of that can vary from firm to firm, from practice to practice, whether it means, every time when you hire new lawyers, you have a meeting with them and orientation, and that's part of the orientation. And then you have some type of ongoing, regular reorientation for all lawyers in the firm on some type of regular basis. But just to make sure that connection is kept and that connection is made, that everyone understands their responsibilities. And I mean, it seems like it's a given, and that of course everybody, you take professional responsibility when you're in law school. You have to now. Thank God I didn't have to take the extra test, but now everybody has to take the MPRE. You think that you're oriented, but it's always good to keep refreshed and to make sure that the lawyers understand what their duties and responsibilities are. When it comes to the responsibility of a supervisory lawyer for the actions of a lawyer that they supervise, when can that person, the supervisor, be held responsible? And under the rule, it's not all the time. It's in very specific circumstances, and that would be it. A lawyer shall be responsible for another lawyer's violation if the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved, or the lawyer is a partner or has a managerial authority or supervisory authority and knows of the conduct at a time when the consequences can be avoided or mitigated, but fails to take reasonable remedial action. So that's the very specific. You either have to condone it, direct it, ratify it, or you have to know about it and don't do anything about it to correct it. That's when the lawyer, supervisory lawyer, can be held responsible for another lawyer's conduct. With regard to the non-lawyers under Rule 5.3, the language is very, very similar, that it is the supervisory lawyer's responsibility to make sure that any non-lawyer that works for him or her has an understanding of the rules of professional conduct that apply to the lawyers and what the lawyer's responsibilities are, and that the non-lawyer staff, the non-lawyer employees are expected to conform their conduct to those rules and to not do anything that would be a violation if it was done by the lawyer. Now again, I will hasten to say that the non-lawyer cannot be directly disciplined by the bar or anyone else for violation of the rules of professional conduct. But the lawyer is going to be looked to even more closely than in the supervisory position to another lawyer. The language making a lawyer responsible for a non-lawyer's conduct, again, is very similar, but it's the key difference is if the lawyer knew or should have known at a time when the behavior could have been corrected. So that extra little piece, the should have known, broadens a lawyer's responsibility for a non-lawyer's conduct that could potentially be a violation if the lawyer engaged in the conduct. So that's the broad brush that you have to be aware of, that you are responsible. So, and it goes back also to Rule 8.4 that says a lawyer shall not violate another rule of professional conduct or do so through the acts of another. Yes.
I'm sorry. May
Yes,
I-
please. We have.
Okay. Hypothetical. Partner, and this is purely hypothetical. Partner in the bankruptcy practice of a huge firm, Richmond, Washington, wherever, becomes aware of a situation in another department, in the litigation department, that is a clear violation of the rules of professional conduct. The bankruptcy partner goes to the managing partner of that office and tells him or her of the situation. The managing partner says, I'll take care of it. A, the managing partner never does anything, and B, the partner who relayed the information to him does not follow up on it.
The hypo basically is if a lawyer in a firm, let's say a partner of the bankruptcy group, becomes aware of some problem with a lawyer in another department. And so the bankruptcy partner goes to the managing partner of the litigation group, let's say, and says, you got a lawyer that's got a problem, can you address it? Managing partner of that lawyer doesn't address it, nothing changes, and bankruptcy partner just kind of goes back, never follows up. Is there exposure for either one of these lawyers, the bankruptcy partner or the managing partner?
That's exactly the question.
What are your thoughts?
I think potentially that there could be, yes. If under Rule 5.1 that says if the lawyer in a partnership, managerial position, supervisory position knows of conduct that is in violation of rule and does nothing to remediate then yes, potentially that if it explodes into something, then yes, potentially that partner.
I see both still having serious problems.
Both. Yeah.
I think both are going to be equally responsible. You don't get to just say, oh, so-and-so's being bad and just, well, I've done, and walk away. You don't get that. Now, let me explore this just a little bit from my perspective. You know, for years, I would challenge you, looking back through the last decade, 2-3 decades, to find a lot of disciplinary claims that are a 5.1, 5.3 violation. There just aren't that many. And if and when you did find it, it was all about somebody stole some money. Okay? And typically the first time that something like that would happen, there would be a slap on the wrist. Because the defense always was, I had no idea this lawyer would go rogue, or that's the, well, now don't let it happen again. Not anymore. This happens so frequently. We have had firms disbanded by court order, and orders saying these lawyers are incompetent when it comes to handle money, and they're forever prohibited from being personally responsible for money ever again. I've seen that court order. Lawyers are losing their licenses because they did not take proactive steps. People steal. You need to know that can happen. So I'm just giving an example, and I'm saying times are changing, and we're really looking. Barbara reference some language that talks about practices and procedures. Well, what does that mean? And if you look at commentary, it talks about having systems in place, effective calendaring systems, conflict systems, and trust accounting systems, and these kinds of things. And I challenge you and encourage you to think about, we're taking these rules more and more seriously, out of necessity, but I personally think it's a good thing. So, and I want to just tell you one little quick story on this 5.3, you should have known kind of stuff. How far does that go? You really do need to educate your staff about confidentiality, as an example, and make sure that they know all the rules there. There was a situation in another jurisdiction, this is a few years back, but the lawyer is a personal injury lawyer. I had an enterprising paralegal. It was kind of a two-person shop kind of thing, And there was a train accident and a spill, and a lot of people injured in all this. And in violation of the rules, the paralegal, trying to do good, earn that bonus check or whatever, sends out this mass email offering the services of the lawyer and doing all these kinds of things. Now, the bar went after the lawyer, and the lawyer is saying, I didn't tell her she could do that. Honest to God, I didn't even know you could do that. He got suspended. He should have known and understood that this is a way technology can be used. And he should have known to have a discussion and educate. I mean, he said nothing to the paralegal. There were never any discussions. He'd say, so I'm telling you, the world's changing. Okay? We take these rules seriously. Question or comment? Let's look at the third hypo. You just finished your first week of work at a new law firm, and you already have some qualms. In particular, the partner who supervises your work seems to be a bit, shady. You begin to wonder what responsibility you might have if your supervisor asks you to do something that makes you feel ethically uncomfortable. May you be held responsible for conduct you undertake at your supervising partner's direction. Who thinks yes? Okay. Do we have any no's? Okay. It looks like we're pretty uniform, yes. Yes, you can. Yes, you can. And that's uncomfortable for some. And we have an interesting situation here in Virginia, you know, in terms of not having, 5.2, isn't it?
Right. In your materials, it'll say that there's ABA Model Rule 5.2. We do not have that. We did not adopt that.
Which was, in essence, something of a safe harbor
Right.
in other jurisdictions.
You know, if you were a safe harbor, if it was, you know, I was just doing what somebody else told me, but we don't have that rule. Every lawyer is responsible for his or her own actions, and whether that's coming from an instruction from a supervisor or not. If you know that it's improper and you do it anyway, you face the consequences yourself, as may the supervisor, but you will face the consequences. And I have to say, it is the real life piece of this. We hear over and over, and it's very disturbing to me, I have to say, because we hear it more and more, or we've heard it a lot from very young lawyers, new lawyers, who are just getting out, and it's a terribly tough market now, and they're taking jobs where they can, and they will call us and say, I just took this job, I've been at the job for anywhere from just a few weeks to just a few months, and the owner, the partner is doing this, and I know this is wrong, and, you know, he's not handling the money correctly, and he's, you know, there are conflicts, and he's wanting me to do all these things for the client that really are improper, and what do I do? And it's a horrible, horrible situation for these people, especially these young people who, they need this job, they've got to pay their bills, they just started, they're put into an absolutely untenable position, because if they don't out the door. If they do it, they're probably out the door, because they're going to be putting their license at risk. So it's very disturbing to see this happening. I don't know, it seems as though, and maybe it's just from my perspective, but it seems as though it's happening more than or at all than I've ever heard it from coming up through my practice. But it's really something that we've got to be aware of, and that, you know, you can't instruct somebody else to do something that's improper, and if you're in that position, as bad as it may be, it's something that if you have to raise the issue, you have to refuse to do it, but it may cost your job. So
it's a catch-22. I saw this hand first.
That's fine.
Yes.
Has the bar actually gone, when somebody can tell us, Ethics Counsel, that a young lawyer tells about their supervisor, what does Ethics Counsel do with that? Does Ethics Counsel go after the supervisor, or because it's confidential so you can't do anything with it?
The question is, you know, if a young associate in this pickle contacts the bar, what does the bar do with this information? How does the bar respond?
If we get this through the ethics line, through an ethics question, we truly will bend over backwards to guide the person through, and to help them, you know, take the action they need to take. But to answer your the direct question, do we contact the partner or go after the partner based on that information? That answer is no. The ethics inquiries all are confidential, and including and it doesn't happen that often. It truly does not happen that often. But on the occasion when someone will call after the fact, after something has happened, or in the process, we do not report anything out from the ethics line. That's just
Would
our
you encourage
policy.
the lawyer to?
Oh yes. Oh
Okay.
yes, absolutely.
See, that's what I want you to hear.
Absolutely, yeah. I mean, we will help the lawyer do what they need to do, and that they need to make a report themselves, because that's will be part of their duty.
And we were kind of talking about in the earlier, the failure to report and talk, you're now, the ethical conundrum's getting worse. And it really is a catch-22. I appreciate that. But if and when you find yourselves in any of these situations, life's too short, folks. I'd encourage you to step up, do the right thing, and move on. Yes?
This is more an observation than anything else. I served on a district disciplinary committee for 3 years. And I can't remember a single case in which we had a complaint against a lawyer. Now, afterwards this has happened, but a complaint against a lawyer in a large firm. The brunt, at least back then, of, and when was that, 2003 to 2006, the brunt of the cases we had were solo practitioners or very small firms. Now, in this hypothetical, I guess you're hypothesizing the associate and the one partner. If it's a 5-lawyer firm or a 10-lawyer firm, then the lawyer who's been instructed to do something wrong, would be foolish not to bring it to the attention of someone else. And I certainly don't speak for other district committee members, but that would be very powerful in terms of determining whether the sanction would be a written reprimand or a de minimis dismissal. So, you gain nothing by remaining silent if there's someone else you could talk to.
Yeah. The comment is just really exploring the difference between something like this happening between a new associate and just a senior lawyer in terms of two-man shop versus 5, 10, 20 and on up attorneys. And it may be a little bit easier if you were in a larger firm and it's my senior lawyer and I'm the young new associate that I can go to others and who knows how that'll play. But should bar counsel ever get in, the fact that you did something and tried internally to work with it may be something that bodes well for you in terms of mitigating the harm that can come down the road in terms of discipline, these kinds of things. Let's move on and start to explore some real day-to-day kinds of things. We're going to look at hypothetical 5 for a moment. Your client tends to be a hands-on participant in her legal matters. Over the past few months, she has expressed some frustration at the civility that you have shown toward the lawyer representing your client's adversary. She tells you that she thinks the other lawyer is taking advantage of you and wants you to start being a little tougher when you deal with the other lawyer. And, sometimes trust me, sometimes these clients are far more, you need to be an SOB kind of thing, or, they really, really push this. But when you have a client saying, I want you to be a hired gun, I want you to get scorched earth, and I got the money to pay you for it. What are your options? What do you do here? Does anyone have a thought? Washington, what do you do? I demand it. We're getting beat up. You're looking like a fool. I don't know what is with this, church behavior. This guy is making you look like a weak idiot. Get aggressive. They're screaming and holler at you. They're using, the salty language. And if you don't think this stuff happens...
Is that synonymous, though? I mean, scorched earth and being aggressive on the one hand, as opposed to, using profanity and... Is it different?
I think there is a difference. You can zealously represent and still be civil. I would agree with you on that. But for this hypo, that's not what the client wants. The client is asking you to just get dirty. Rough it up. Roll up those sleeves and let's go to war. Because that's what your adversary is doing to you. How would you respond, Barbara? What is your initial thought? I'm calling you on the phone here. What do I do?
Well, the answer that we, and again, this is where, you know, the rules provide some guidance, but when it comes down to it, this is where, you know, you use common sense and act like a professional. I mean, it's always going to be the advice and recommendation: act professionally, act civilly, don't get pulled into that, because they're really, you ultimately gain nothing by that. And if it is something that is really offensive to you, and that the client is pushing and pushing and pushing, and screaming and hollering and being just enormously difficult, then you do have an option under Rule 1.16 with regard to termination of representation. Under the list of various factors that will be the basis for a permissive withdrawal are if the client wants to pursue a goal that is repugnant or imprudent, or use means to further their case that are repugnant or imprudent to the lawyer. Rule 1.2 in the comments mirrors that, that the lawyers can explicitly limit the scope of representation and exclude actions that the lawyer regards as repugnant or imprudent. So if you really get into that situation and it's becoming completely unbearable and unworkable, the ultimate answer is to the client: see you later, and go find somebody else. And that sometimes is the answer. But to engage in that behavior for just because the client is demanding it and for no good reason, not that there's a lot of reason to ever get that uncivil, but not like that, and not because the client is pushing. And again, I will say, we hear commentary a lot that, you know, this is definitely going on, and it's not just too much lately. And it goes, and I will say it crosses all lines. It's not just the younger lawyers coming up. It's not any one group. It goes across the board. And that too is another disturbing thing that we are seeing. So yes, John.
And then there are some areas that you just can't do it if you value your own license. For example, if the scorched earth involves filing frivolous motions or pleadings. And then the other thing, and I don't know if it's still available, but Justice Lemons, I think, gave a talk to the Professionalism course a few years ago. And he pointed out something that I had not realized, that obnoxious conduct at deposition, if you're at a deposition, the rule says, as at trial. So if you're making spurious objections, you know, Colonel Davis, the bar counsel, might be knocking on your door.
Yeah,
That's true.
See, there's some boundaries here. You know, we can't just, the frivolous motions run amok, you know, can be a real problem. Depositions, we need to be very, very careful. It's, you know, and as an aside, if you've got somebody playing games in depositions, you know, sometimes we say, what do you do about that? Well, one of the things is maybe stop and let's say we're going to start making a recording going forward. And even, you know, the thought that this is going to be videotaped or recorded in some fashion is enough to put the brakes on the other guy. I really believe when we are facing situations like that, there's value in just trying to educate the client. You know, why won't you do it? Because I choose to be the bigger man, or that's not how I practice law. A lawyer was sharing yesterday, they actually have this as not only a comment that they share in these situations, but I think it's in their engagement letters. They have a way that they, and pardon me, I'm just forgetting what he did specifically, but his comment is, We tell all of our clients, we fight fire with water. I love that. I love that. You can also say things like, you have to understand civility or being uncivil comes with a cost. I want the judge to look at us in good light. And if you or I are acting, it's even natural for people in an unconscious kind of way to be turned off. So there are those kinds of things. And just be aware, there have been some studies looking at this. What kinds of results do the hired guns get compared to the civil lawyers in terms of actual outcomes? Turns out they're almost identical. No statistical change in any way, shape, or form. So the aggressiveness doesn't alter the outcome. And one final thing to think about, folks, what goes around comes around. I'm always surprised by these guys that are out there just being the angry dog kind of lawyer. And, they've got this vengeance suit and the client, money be damned, and on and on and on. But when the client, after spending all this money, doesn't get this huge outcome, or it looks like, the other side really didn't get taught the lesson and these kinds of things, well, they turn around and sue you. You're seeing how they're going to treat you if you don't have the outcome that they expect and want. So I'm just going to throw that out there as well. Let's keep moving here. I'm going to jump to 15. I'm going to jump to Hypo 15, and this is just because it's so common. Your first supervisor frequently reminded you to try your best to return all telephone calls, or have your assistant return them by the end of each day. This has become increasingly difficult as emails have either supplemented or replaced telephone calls. One of your newest associates just asked you several questions about this type of constant communication. The first question that was asked, should he still try to respond to each communication on the same day in light of the deluge of modern electronic communications? And B, what should he do if the adversary's lawyer does not return his phone calls or emails? And why this is important. What the two most common things you see in discipline? Well, one of them is somebody stole some money. And the other is the lawyer never returned my call. All over the country. And that actually is the leading complaint about lawyers. I'll share a malpractice issue with it in a few moments. Let you go ahead. What are your thoughts about this? Where do you come out?
This is as Mark was starting to say, this comes within the scope of diligent, competent representation and your duty to communicate with your client and keep in communication with your client. So you've got rules 1.2, 1.1, 1.3, 1.4. And you need, and it is, today with the deluge of phone calls, email, social media communication, all of that, it gets to be a little overwhelming, but you've got to try to, you've got to respond, find a system that you can put in place. Either you mark out a part of the day. This is what I hear a lot of lawyers do. They mark out a part of the day. This is when I'm going to return phone calls. I'm going to answer email, whatever, or work with your assistant in that regard. But do something so you are keeping up with that and you don't let that go. If you're going to communicate by email and that is going to be a means of communication, then you've got to keep up with it. If you don't want to do that, then don't have that as an option. It's about establishing your boundaries, establishing your parameters as to what you're going to do or what you're not going to do, and how you can best work within those to make sure you keep communication and you keep diligent representation and keep the client happy. One thing I will remark about, because that is brought up, what happens, it's one thing when it's the communication between you and your client, and you've got a duty to communicate with your client. The question and the aggravation that comes up over and over again is the other lawyer won't respond to me. I write, I call, I send flowers, I email, I do no response. And what do I do? Because we're going along and now this deadline is coming and this hearing is coming and that motion is coming and I'm getting nothing. And the next question after that from the lawyer will always be, so couldn't I just contact the other client instead? Because obviously the answer is no. No matter how difficult, how intransigent, how impossible another lawyer may be to communicate with, you cannot circumvent and go directly to the client, so long as you know that that lawyer is still representing the client. So in those situations, you do what you have to do. You make sure that you are communicating with your client, and that to the extent that there is required communication or notices to the other counsel, you do that and you keep everything documented. And then it may be that you find a way to bring the issue into the court to make the other attorney appear somewhere and answer for what he or she is doing. But what you cannot do is make an end run and contact the represented person or party directly, because you're not getting, because therein there is no duty on specific duty under the rules for lawyers to have to communicate with each other.
Let me ask a question.
What would you consider, I guess, a reasonable time to respond? I guess for one, to the clients, but then also opposing counsel or opposing party.
It's a great question. What do we consider a reasonable time to respond, whether it's a client or opposing counsel? Let me tell you about an interesting study that was done. You know, I love this hypo because it starts out, you know, the old school senior lawyer taught me this same day or 24-hour kind of, you know. Is that actually still the way it is? If you poll lawyers and say, what is the expectation when it comes to responding to requests for information? And that's just talk about the phone for a moment. And it turns out that lawyers say the community standard, if you will, what people reasonably expect is 24 hours. If you actually go out and talk to the general population and kind of do this study, what do you expect a reasonable service, these kinds of things? What do you think the answer is? The answer is 1 hour. There's a disconnect. And I think part of that is because of, again, these evil things. I mean, there's a lot of good about them, but you get, I mean, the fact that we're constantly connected. All we do is insure lawyers. We work day in and day out with people that are suing you. And we hear this all the time. People will sit by their phone if they think the lawyer's going to call. They will not go to the doctors. They will not go to the dentist. They will not pick up the kids from the middle school. Do you know why? Because for them, it's their divorce. And that's the most important thing going on. You know, for us, it's, well, this is just another divorce. It's just another whatever it is. You see what I'm trying to get at? So just be aware of what the real expectations are. You can't always get back in an hour. And I would suggest that the difference between adverse counsel and a client, I don't make any distinction. I'm going to be civil and try to get back as quickly as I can to both. That's what a professional does. And I'm never going to try to be the other guy that's not responding and all of that. I will also tell you, be careful and sensitive about the messages we give. If you can't get back right away, have a secretary. Somebody else contact. The lawyer has the message. Is there anything I can help you with? He or she's still in trial. These kinds of things. Let them know. You could also say, even up front in an engagement letter or something, our policy on returning phone calls is, set the expectation so that they aren't sitting, waiting. I just texted him. Why isn't he, and they do that. But understand that failure to return calls, failure to keep your office clean, responding to requests for information, these kinds of things, we view it as a professionalism issue, and it is. But I'm going to tell you how clients respond to it. I'm not important, and they're not putting enough effort. And that's why I didn't get the outcome I expected. I wasn't the important enough client. They really didn't care. I wasn't, enough money. They tell us this, folks. Clients equate these professionalism issues as saying something very, very directly about competency. So all I can do is share that information. Now, one final thought. Getting back to this. The temptation, particularly with email, and the younger we are, it seems to be the more we do this, we want to respond immediately. Stop. Think about it. I'd rather see you return a phone call sooner than an email. Because two things happen in email. You might get the other side is, being one of these nasty, salty, and I just want to, and I let her control my emotions, and I say things that I shouldn't say. So, and we can do that with clients too. I think there's value in just taking a step back and thinking about it. But we've also seen this more than one or two times. Oh, this is a quick question. Done. And we forget about it. We go on. 2-3 hours, 2-3 days, 2-3 weeks later. Oh, I forgot. You're answering questions sometimes in a vacuum, and you don't have all the information, or thinking about taking the time to ask, well, what about this? And trust me, people know how to ask the question to get the answer they want to hear. So in other words, don't give advice in a vacuum. Very, very easy to do in email, and we've paid the losses for it. So just something else to think about. That's briefly hit one last issue. I'm going to look at 22. Lawyer is excited to use social media to build her practice and has started a blog. When blogging, she posts information about general topics related to her area of practice and also results in information from her successful court cases. Another win today, that kind of thing. She has not been getting client consent to post this information, nor does she include any sort of disclaimer about case results. Also, now that her practice is getting busier, who has time to do this, she has looked into having a company ghost write some of the general information topics so that she can put her name on them and get things posted more quickly and keep the blog active. Well, is the lawyer in violation of the ethics rules doing these kinds of things? What do you think? We could even go way out there. Do the rules even apply? Do the rules apply to Twitter? LinkedIn? Come on. Yes. Yes, they do. We need to remember that. Briefly, Barbara, let's kind of just run through some of these. Can I post information about clients without consent on my blog? And I suspect you're not real comfortable with the outcome in Virginia, because in a lot of states, what happens here is not the way it is. But
Well, here's and this is in your materials, and I know everyone who's seen this because It's been one of the most publicized cases, the Horace Hunter case, where he blogged, had information about his clients' cases, went through discipline, went to the Virginia Supreme Court, and the outcome from the Virginia Supreme Court was, with regard to the publication of information about his clients without permission, so long as it, because he showed that the information they put on his blog came from public sources and information that was in the public, that was not going to be considered a violation of Rule 1.6, the confidentiality rule, and didn't have to have the consent. However, because he was using the blog as a means to market, he was still subject to the advertising rules, where you still have to have a disclaimer with regard to specific case results. So that's the status of things at this point. I will caution, notwithstanding the findings in Hunter, that if you are going to be talking about your clients and your clients' cases, still take care, because it's a fine line from, if you start talking about your clients' cases and it's information you have because you represented them, and it might not really be out there in any public source, you cannot do that without your client's consent. So still be aware of that. Not even in light of the Hunter decision.
I would get their consent even if it is public information.
I would. I mean, that's. Really,
I don't want them bad mouthing me. Reputations can be destroyed like that.
Exactly. I mean, I think that our position would be to advise you that that's always the best. I mean, do a little extra, and then you don't have to worry.
We're really up against the hour. I do want to throw out this ghostwriting stuff. It's an interesting situation. There's some developing opinions now that are saying ghostwriting and putting your name on it, not okay. It's misleading. I'm not saying you can't use these services, but I think the better way right now is to simply say, hey, here's an interesting article we found from such and such, or written by such and such. Please enjoy. I hope you find it, that kind of thing. But to post something that is substantive, if you're going to put up a recipe or something, I don't care. But, substantively significant in terms of, state planning update, that kind of stuff. And to put your name on it when it's not you, right now, a number of bars are looking at this and saying, we're not so sure we like that. We could call it for what it is, plagiarism. So I'll wrap it up because I know you have another program starting here. Thank you very much. I hope you found something of value today.